Okay, here we are. I'm going to pretend that you are a client, and we're talking about getting basic estate planning documents in order. Some people are able to present information easily, and others have quite a difficult time in getting some basic information so that we can get moving with establishing basic estate planning documents. So, wherever you may be, as far as that information being very easy or more difficult, I just want you to have this in your mind so that you are ready to move forward with basic estate planning documents. So, basic estate planning documents, we have the will, power of attorney, and healthcare proxy. Let's start with the healthcare proxy. That document allows you to name an individual to act on your behalf when you cannot communicate with the doctors. So it only kicks in when there is a need because you cannot communicate one way or the other with the medical professionals. You name one person at a time for obvious reasons. We cannot have a conflict and have two people wanting different things. So one person at a time. Now, of course, there can be people in the picture and people talking to one another, but on the document and in crunch time, we need one person to act at a time. Now, for the healthcare proxy, we need the agent's legal name. We need the agent's current address. And we need the agent's phone number or phone numbers, because the doctor, or whoever it may be, will look at the document and see who they are to call and call that person. We want the health professionals to know who to call and have the correct information to call that person. Now, the healthcare proxy may have some additional information in it. I usually start mine with a living will that is part of the healthcare proxy. And there can be a difference of opinion as far as that goes. There can also be information as far as what you would desire with your remains. However, there can also be another document called the appointment of agent to control disposition of remains that can be very beneficial, and that can be done as well. There can be other information in that healthcare proxy as far as electronic communication with medical health professionals and so on. But for purposes of this video, we're thinking about organizing information. And so for the healthcare proxy, you are thinking of those people who will act on your behalf when you cannot communicate with the doctors, medical health professionals. You need to establish who is first, who then would be the alternate, and you can go from there. Second alternate, third alternate, whatever you want. Full legal names, current addresses, current phone numbers. So I would say that can be a starting place for people as far as thinking about getting information ready. Now let's move on to the power of attorney document. So this document allows another person to act on your behalf in financial matters. Financial matters can be quite broad, as well we can add modifications here in New York into the power of attorney document that allow for a whole range of possible options and powers for the agent. So you are signing this document called a power of attorney, and you are the principal. Once you have signed as principal, and here in New York, we need 2 witnesses who witness the principal executing the document. Then thereafter, the agent or agents can sign the document. The agent or agents must sign the document just like the principal, in the sense that they must sign before a notary. No witness is required for the agent, but a notary is required. So this is something to work out as far as, do you want to execute the power of attorney document and leave it at that until a need arises as far as having an agent act on your behalf. And then at that point, the agent can execute the document before a notary so he or she can act? Or do you want to have the agent or agents sign the document as soon as possible after you have executed the document? Now, as far as information, we need to know, who do you want to act on your behalf in financial matters? We have a primary agent or agents so that you can name 1 or 2 people right from the get-go. Now, sometimes that can be very helpful depending on your situation. Maybe you have an elderly parent who wants to name his or her spouse as a primary agent, but also wants to name an adult child as a primary agent, so that either spouse or adult child can act if the document is executed correctly. You can have other situations where you are not sure who will be around and able and willing to act on your behalf in a time of need. So you do name 2 agents to act primarily on your behalf in the event it's needed or desired. You can also name 1 or 2 agents as alternates or successors. So if the primary agent or agents cannot act, we look to the successor or the successor agents. And then again, we see, do we have 1 or 2 successor agents with the same kind of thoughts? You may only want 1 for specific reasons. You may want to have 2 for other reasons. When you are naming 2 agents, whether it's in the primary spot or the alternate spot, you need to determine if they must act together or they may act separately. Financial institutions tend to not like 2 agents having to act together. It's liability that they do not want. Some financial institutions don't like power of attorney documents in general. And so we have a discussion as far as potentially setting up a trust at some point for certain assets for certain reasons. And that's for another day. But the power of attorney, again, allows a person called an agent to act on your behalf. You determine if you want one or two primary agents, and you determine if you want one or two successor agents. If it's going to be two in either position, you determine if they can act separately or they must act together. So we're talking about gathering information. We need to gather the information on the agents. Who are these people? We need their legal names and their current addresses. Then we're going to have a discussion about certain powers, what should be in the power of attorney document, the power of attorney document itself, how we're handling all of the execution matters as far as principal signing and then agent signing. And there's a whole host of things that we talk about in that regard, because some people do get concerned about who would have a copy or even an original of the document, and how are we managing all of that. I'll save that again for another day. We're talking about gathering information. Now let's move on to the will. The will is the document that takes effect and only takes effect upon your passing when we need to probate the will. We need surrogates court to find that this document is indeed your last will and testament, and that we need the fiduciary appointed, typically the executor, and the executor follows the terms of the will. The power of attorney, the document I just talked about, ends at death. The agent cannot take any actions once you've passed. The power of attorney document ends at the moment of death. So there may be a gap in time between when that power of attorney is effective, you're living, and when you have passed away and we do not have a fiduciary appointed yet. But the will is what will govern for those assets that are in your name alone and will pass through your estate. Basic information for preparing a will means: who are your next of kin? Who are the people who would inherit per New York State law if you didn't have a will? Because those are the people that you must know about in your mind when you are preparing a will to show part of the requisite testamentary capacity to even prepare and execute a will. If you're you have an estranged child, and you do not bring up that you had this child but are now estranged from them, and that comes out later on in a will contest, that's going to be a problem as far as showing you had testamentary capacity and knew the natural objects of your bounty at the time of preparing and executing the will. So having next of kin information means a whole host of different things for people. Because let's say you're not married and you don't have children. Well, then we go up to parents. If we don't have parents living, we go to siblings, and so on. So you would always work this out with your attorney as far as making sure you have your next of kin down. In some situations, it can be simple. In others, it gets much more complicated. Now, moving on, we need to know about assets and debts. Assets, because again, that goes to testamentary capacity. Do you know what you have? That can be another reason why there can be a will contest. You did not have testamentary capacity. You did not know what you had. As well, there can be concerns about estate taxes. And so we would think about options if that were a concern. We also want to know, how are assets titled? Very important. Is it an asset in your name alone? Are you a co-owner with someone else? Do you have a business interest? If so, is it a corporation? Or is it an LLC? And so on. If you have bank accounts, do you have beneficiary designations on those bank accounts? Do you have payable on death designations with any accounts? You'll go through this with your attorney, but you need to know and list out all of your assets, how they are titled, and approximate values. This is also a great opportunity to bring up some potential concerns in regard to all of your assets, how they are titled, what other arrangements need to be made, have you checked on beneficiary designations, and so on. So it's a great opportunity to review what you have, to make any necessary changes, and of course, in preparation of the will, providing that you have this testamentary capacity. Debts are very helpful to know because it's going to help as far as the planning that is going to be done and if it makes sense, and also another opportunity to point out some potential red flags. Now, of course, every will has an executor nomination. That's the person who you find to be responsible, trustworthy, communicates well with people, can work with professionals, can do what's necessary to marshal estate assets, pay estate debts, pay estate administration expenses, file final personal income tax returns, open up the estate checking account, do everything that is necessary, and work with attorneys and so on, and get that estate closed efficiently. So you are thinking of this person, and we need, obviously, full legal name of this person and their relation to you. You're also thinking about a successor or an alternate, and you can have a second successor, an alternate, and so on. Some people have this type of information more in their head than others. They kind of have a go-to understanding of what needs to be done. Others do not, and it takes some more work. Others may need to rethink what they thought was 100% what they were going to do. So it's a great time to step back and think about what you're doing and who's going to be counting on this person called an executor to handle the estate. It's a great role as far as responsibility goes, and people are counting on that person to be responsible. I've seen too many situations where that person was the wrong person. So please think about your executor nominations very seriously. Now, depending on what you are doing, if you have minor children, you are thinking of nominating guardians for your minor children. If the other parent has passed and your will is the last document standing as far as providing for guardian nominations, then of course it's extremely important. But parents are natural guardians of their minor children. So this would be in event both parents have passed, what are the nominations for guardians for the minor children in the will? And we would work on this, but you're thinking of the appropriate people. And same thing with executor. You can name a person and have an alternate and another alternate. In this case, you can have guardian of person separated from guardian of property, but so often people will put the two roles together, guardian of person and property. Now, you may have a trust in a will, and the trust in the will could benefit minor children, but you could have a trust in a will that benefits surviving spouse or any other number of possible individuals. But if you are putting a trust in a will for whatever reason, then you're going to have trustee nominations. Same thing. Who's going to be your trustee? Do we need to have a co-trustee? We'll talk about that. And then alternates. And then how are we filling in a vacancy in trusteeship if that were to occur? And you're going to work on this with your attorney as well. Now, then we get to what do you want in the will? And I'm going to stop here right now because I really just want to think about starting the process of gathering information. And at this point, we're gathering people information. People will affect you, will affect what you want. And we need to think about gathering information on people. And that can be step one. If you're stuck or you need to rethink or review or revise what you've done, you can start with people. And then we get into some assets and debts and things like that. But let's stop here. I'll pick it up on another video. I hope this was helpful. This was Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. And I look forward to seeing you on another video.